coming? Sue? Is Mark gonna be here?
I have no idea.
I'll check real quick.
I believe this is what Sue is wanting.
What you signed, we should have printed. So I printed your name and did a little arrow for you.
Thank you.
It's the least I can do.
Good man.
You're not gonna be counted as being here now.
Yeah, I know, that's, can't read your writing.
Yeah, probably.
Are you ready, Ms. Ross? How are you? Good. Good. Mark? Oh, okay. All right, he's not here yet. Okay, thanks. Okay. He's on his way.
So, okay, we can, unless you object, can we wait a few minutes?
Sure, sure.
Thank you for the heads up.
Pardon?
Thank you for the heads up about that.
Oh, no
I
problem.
appreciate it.
Is there a back way in here, do we have to still go in and out that way?
You can get a horse and travel right.
You know, that's not useful.
Or you could probably come, oh, that'd be just as bad coming in this way.
No, I just wondered.
You
No,
can go
yes.
left and then make a right at the end, but it's,
No, I just,
parking, a nice.
when I saw it was detoured, I almost went back on Southern thinking I was going to the next
Yeah.
stop, and I said, I don't think that's the case, no.
It's been like that for a month or so.
Hmm.
Yeah,
Hey, Mark.
Well, you were close.
Did you want to step on Mike?
How's this? Is this better for you all? All right.
Okay, are we ready to start? Everything's rolling here technologically? We're all set? Okay, let me call to order the Town of Waxahachie Grove Special Magistrate Hearing for today. Today's Wednesday, October 16, 2013. It's about 10 o'clock, and this first thing I can do, I guess we'll have witnesses. Let me swear in the witnesses. Do you swear the testimony you'll give will be the truth, whole truth, and nothing but the truth? And just skipping down the agenda, I don't think there's anything we need to deal with other than the Magic Properties Valley Crest case, right?
I believe so.
So we have the fine, in essence, a fine assessment slash fine reduction
Right.
hearing, which we can obviously do all at once. As you all know, we started the hearing. I have a whole bunch of exhibits. I didn't have a chance to read everything. We decided to wait a month to see if there was any more information the town might find in your records as far as what happened with this application, given the history. So let me turn it over to the town first.
Mr. Magistrate, Mike Cirillo, Town Attorney, from Town of Waxahachie Groves. Yeah, I reviewed, I was not at the last hearing, and in speaking with Mark and Bev and looking at the minutes, it appears that the open issue really is what effect the town's moratorium ordinance had on the ability of the respondent to file the site plan if they desire to do so. So I went and I took a look at it. You know, I was familiar with the resolution, and it had been extended. It wasn't just that resolution. It had been extended and concluded, I think it was in May of 2011, when the comp plan became effective. And so in looking at that resolution, it does not appear that it would have allowed a site plan application to have been filed during its pendency. You know, did not specifically list the site plan, but it listed development orders and development orders that change approved uses. And that's what this case was about, was it wasn't approved previously by the county commission. So, given that, I've taken a look at the second legal issue as well, and confirmed with the town that is appropriate, that no fine be imposed during that time period. And I believe this was an issue resolved in the last hearing where code matters were abated. And so with that, when you factor in the time period that was affected by this case between the moratorium and the abatement, you would eliminate most of the time frame of the fine amount. And what would be remaining would be the time frame where neither one of those were in place and no compliance had been incurred. And by our calculations, that's about $8,100. That's 81 days, I believe, at $100 a day. There's administrative costs associated with the code case, I believe were testified to before. We can put on the record if you want, but I think it was
$1,147.50 plus a $400 administrative fee at the point of the order of violation.
That was the amount awarded way back when?
Yes.
Okay.
So it's respectfully the town's position this morning that the fine amount of $8,100, which covers a time period not covered by those ordinances and resolutions, be the fine amount imposed in this case, plus the costs.
Okay.
And just one other thing, the $100 a day was imposed by your predecessor.
Yes.
But at the time, they would have been obligated to consider the statutory factors in reaching a $100 a day fine. And that's why we don't think that per day fine should be reduced at this point.
Okay.
And I turn it over to you for any questions you have of staff or me or Mr. Coviello on behalf of the respondent.
Just a question, was there anything found, and maybe it doesn't matter given where the town's position is now, was there anything you found in the record as far as attempts to seek site plan approvals, attempts to do whatever by these folks in that window of time?
There was the one attempt that we had submitted as an exhibit where an attempt had been made by one of the employees, managers with Valley Crest in terms of the zoning designation on the property. And then beyond that, it just kind of fell off and there was no other attempts made.
Is there anything in the record, and I know from November of 2011 on, there was no order saying there was going to be no fine, but what happened from May of 11 until, it took about 2 years to get a site plan anyway? Is that just what happened? Or is that question for this side?
Yeah, I think what happened, by the way, before I answer that, I'm in agreement with what the town attorney just stated. When we submitted this site plan, which I believe is in the record, we couldn't go through the formal site plan review process, so we submitted this and we worked with Calvin Giordano, the prior code enforcement company for the town. And quite frankly, my client thought that the issue was resolved. They weren't represented by counsel at that point. They thought the issue was resolved until they received a notice to reappear. I think it was in November 2011. So during that, they assumed it was taken care of based on this site plan.
From that point forward, and again, I guess it doesn't matter too much, it was more curiosity, it took until sometime this summer until the site plan was approved.
It was a lengthy process, in part because of, I know the town was formulating different, I think it was a DRB that they had to formulate. It was a lot of back and forth with the town. It's a complicated situation with the two codes having, the new code being put in place and trying to satisfy the old code and yet come closer to compliance with the new code and working with the town with the new process. So it did take a while. I think both parties worked together well, and I think both parties acted in good faith to move it forward, but unfortunately it did take a while.
And I will say, I think that's why there's only 81 days of fines on that, is it went to the time when they applied. And also, just to make it clear, they did come into compliance when they got their April site plan approval, I believe. That's when they were originally approved, was in April.
That's correct.
April
But
of this year.
But one of the conditions of that from the town council was that they come back with an amendment to adjust the use on the site to eliminate, I think it was the nursery component. So that came back as a site plan amendment, so, so the compliance wasn't as late as the summer, it was actually the spring, for this case. And then, again, that's how the fine got calculated, through this 81 days.
Okay. In light of the town's current position, and that basically adopts, you have your letter with the mitigating factors 1 and 2, that sort of gets you to number 2.
That's correct, yes.
And anything you want to add other than what's in your letter?
No, like I said, I spoke to the town attorney prior to the meeting, and we're in agreement. I spoke to my client. If you would agree that the outstanding fine would be reduced to $8,100, we would accept that.
Okay. Well, interestingly enough, that's what I thought coming in. It made sense. I had read it and, looking at the dates, and you laid it out pretty well in your letter with the moratorium and the, okay. How about costs? Do you want to address costs?
We're also in agreement on the $1,147.50 plus the $400.
Okay.
I think for a grand total of $9,647.50.
Okay. Is there anything else we need to even talk about then?
Nothing else.
Unless you've got any questions now.
No, I don't have anything. Let me do this then. I will enter an order, I guess actually imposing
Right.
a fine in the amount of $8,100 for that window of time, as indicated. I won't go through the dates, but whenever the moratorium expired and the order was entered saying that the fine would be put in abeyance. So $8,100 plus costs in the amount of $1,147.50 plus the previous costs of $400. I'll reference that in the order. It's not a new award. So I'll do that. Anything else we need to address?
Is there a time frame in the order? I don't know if you typically do. I don't know if you want to propose a time frame for payment. I don't know if it's typically in the order or not.
Usually is not. I mean, obviously it would be assessed as a lien if it's not paid. So I don't know if you want to.
I don't require it. I just didn't know if you did, and then we needed to talk about
Yeah,
it.
if you want to include 30 days, I'm sure that we'll get it paid sooner than that probably. But
Well, I can include it, but what if you don't do it? And then what do I do? And you know what I mean?
yeah, if you want to, I prefer to leave it out. I mean,
Yeah, I think we just leave it out. And
If you don't do it, we're going to record a lien, and we're going to.
yeah, the town has its rights, so you do what you need to do if he doesn't pay it. And I assume it's going to get paid. So,
Yes.
well, it was easy, and it's 10 after 10, and we'll adjourn.
Okay.
Thank you, sir.
Thank you.